Hi, my name is Stephanie Grant, and I'm Senior Counsel here in Warner's Detroit office, and today I want to talk to you about the Affordable Care Act's Employer Shared Responsibility requirements. What that is under the Affordable Care Act, you may have heard it as Obamacare or healthcare reform. It requires certain employers to provide their full-time employees with affordable health insurance or face penalties. ACA penalties can be quite significant. For example, in 2022, the penalty could be as high as $2,750 multiplied by the number of full-time employees you have with your company. So for example, if you have 100 employees, that could mean the penalty equals about $190,000. And that's because you can subtract 30 out of that full-time number in that calculation. But it just illustrates how significant the penalties can be. Employers who are subject to this penalty are called applicable large employers. And what that means is that you have 50 or more full-time employees or full-time equivalent employees. Now, when you're determining whether you meet that threshold, a concept that you need to be aware of is called a controlled group. And this is a concept that is prevalent in a lot of benefit areas, but especially with ACA compliance. So to determine if you have 50 or more full-time employees, you're not looking at just a single employer. You need to look at all of the employers within what's called a controlled group. Now, the most common type of controlled group is a parent subsidiary controlled group, where you have a parent company, maybe one subsidiary, maybe two subsidiaries, and therefore you have to aggregate all of the employees among those three companies when you're determining whether or not each of those companies is subject to the Affordable Care Act's employer mandate. So for example, if the parent company had 20 employees, but a wholly owned subsidiary had 30 employees, you'd meet the 50 employee threshold because you have to aggregate those employees together. There's another controlled group called a brother-sister controlled group, and that's where you're looking at 5 or fewer individuals to see if there's enough common ownership to group 2 or more companies together. But same concept is if you meet those brother-sister controlled group requirements, you'd be aggregating all the employees of those companies to determine if you meet the 50 employee threshold. Once you determine that you're subject to the ACA because you've met that 50 employee threshold, the next thing you should determine is who your full-time employees are. And full-time employees has a specific definition under the ACA, and that definition is anyone who is regularly scheduled to work more than 30 hours per week is considered a full-time employee, and therefore you should offer them coverage in order to avoid penalties. This 30-hour threshold might be different than you have for other benefit purposes or maybe for other employment purposes where you have a different definition of full-time, but it's 30 hours per week under the ACA. Now, for employees who might have a variable hour schedule where they work 20 hours one week but 40 hours another week, the ACA allows you to have what they call a look-back period in order to determine whether or not they meet that 30-hour threshold, where you look back over their hours and average them over a period of time, and that determines their full-time status for ACA purposes going forward. Another concept under the Affordable Care Act is affordability, meaning that not only do you have to provide employees, full-time employees, with coverage, it has to be affordable. And under the ACA, affordability is generally defined as about 9% of that employee's income. There's certain safe harbors you can use to determine what income to take into consideration. But for illustration, if someone's making about $5,000 a month, the cost of coverage, single coverage for them, can't be more than $480 a month, just to kind of illustrate this concept of affordability. Another thing that the ACA requires is filing certain information returns every year to ensure that you are complying with the ACA's requirement to provide full-time employees with affordable health insurance if you're an applicable large employer. Those forms are called Form 1094C and 1095C, and they have to be filed annually, early in the year, with the IRS, and also provide copies to employees, and it just helps explain what type of coverage they're receiving and show the IRS what type of coverage you're offering. As a company in the cannabis industry, if you have any questions about whether or not you're an applicable large employer subject to these ACA requirements, who your full-time employees are, or if you have any questions about how to complete those forms, please reach out to me or anyone else at Warner.